All right, members, I'm going to call this hearing back to order. The House Judiciary, Finance, and Civil Law Committee. Going to pick up where we left off in the agenda. Representative Stephenson, I will move House File 393 in front of the committee with the recommendation that it be placed on the General Register. Welcome back to the committee. Please tell us about your bill.
Thank you, Madam Chair. Members of the committee, House File 393 is a straightforward bill that closes a little dead end in our state law. We are currently the only state where if you have a consumer complaint that you bring to the PUC, you have no way of getting to court if you don't agree with the decision of the agency. This bill fixes that problem.
All right. Thank you, Representative Stephenson. Mr. Elwood, I understand you're testifying. Please introduce yourself and go ahead and testify to the bill.
Thank you, Madam Chair. Members, Ron Elwood with Legal Aid. I just want to thank Chair Stephenson for authoring this bill. And this is something that we brought. We've had some occasional problems where we can't get to the commission. You can't. It's sort of we're in a legal cul-de-sac with current law, and this solves that. And we're happy to answer any questions. Thank you so much for your consideration tonight.
All right. Are there any other members of the public wishing to testify on this bill? Not seeing any, we'll move to member discussion. All right, not seeing any. Representative Stephenson, final words on your bill.
Thank you.
Thank you.
You get the memo.
Representative Stephenson did get the memo. Seeing no further discussion, all those in favor of the motion to recommend that House File 393 be placed on the General Register, please say aye.
Aye.
Aye. Opposed? Motion prevails. Thank you, Representative Stephenson. Representative Norris, I knew I saw you here. Yep. All right, Representative Norris, I will move House File 2413 be placed on the General Register. Welcome to the committee. Please tell us about your bill.
Thank you, Chair Becker, Finn, and members. This bill is designed to protect the victims of financial abuse while helping creditors attempt to recover coerced debt from the perpetrator of the abuse. So coerced debt includes situations like the following. You might have an abuser stealing a survivor's identity and using it to incur debt. You may have someone forcing a survivor to take on debt through the threat of force or intimidation, undue influence, harassment, fraud, deception, coercion. Or you could have a situation where you have a survivor who is forced to go into debt by, for instance, prohibiting them from working. The victims in these situations that are covered by this bill include victims of domestic abuse, harassment, or sex or labor trafficking. This bill allows the survivor to seek equitable relief to either, one, prohibit a creditor from holding or attempting to hold the debtor liable for that coerced debt, or two, dismissing any cause of action brought by a creditor to enforce or collect the coerced debt from the debtor. And I want to thank just briefly a number of stakeholders who came together to make this bill possible. The Minnesota Credit Union Network, the Minnesota Bankers Association, Great Lakes Credit and Collections Association, the Consumer Credit Data Industry, and Equifax and InBank. And with that, I've got Mr. Elwood here to testify to the bill.
All right, please reintroduce yourself and proceed with your testimony.
Thank you, Madam Chair, members of the committee. Again, Ron Elwood with Legal Aid, and I want to thank Representative Norris for bringing this bill forward. You know, we've worked in this arena for many years. As you probably know, Legal Aid represents many survivors of violence, and we have worked with the Domestic Violence Coalition folks who are in support of this bill. There is no opposition, and I want to thank the groups that Representative Norris named. We work very closely with them to get to where we are today, and happy to answer any questions. Appreciate your consideration.
All right, thank you. Are there any other members of the public wishing to testify on this bill? All right, not seeing any, we'll move on to member discussion. Any discussion to 2413? All right, Representative Norris, closing comments.
I'll just briefly thank the committee for their support and thank Mr. Elwood. This is Mr. Elwood special, bringing together all these stakeholders to get something really good done for the survivors of these situations and eliminate this coerced debt.
All right, thank you. With that, I will renew my motion to recommend that House File 2413 be placed on the General Register. All those in favor, please say aye.
Aye.
Aye. Opposed? Motion prevails. Thank you, Representative Norris. Moving right along, Representative Curran might jump the order. Is that okay? All right, we will move to House File 822. Representative Curran, would you like to move to recommend that House File 822 be placed on the general register?
Yes, Chair, thank you. That is my motion.
And then I understand you have an amendment, the A4 amendment. Would you like to move that amendment and then tell us about it?
Yes, I would.
All right, please go ahead.
All right. Thank you, Chair and Committee. So the A1 amendment is language that allows, or I should say that prevents that if a, or wait a second, sorry, A4, I'm looking at the wrong one. The A4 amendment, sorry, is two parts. So one is language that was agreed upon between Post and MPPOA. And the section at the bottom just is kind of another agreement where information that is part of an active criminal investigation wouldn't apply because we don't want criminal investigations to be jeopardized by the process.
All right, any discussion to the A4? All those in favor, please say aye. 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 Opposed? Motion prevails. The amendment is adopted. Representative Curran, please tell us about your bill as amended.
Thank you. So House File 822 is a bill related to data sharing between the Post Board and law enforcement agencies. It mandates that an employing law enforcement agency that's investigating an officer for misconduct shares details about that investigation with the licensing authority, which is the Post Board. Current state statute has a cumbersome court process involved, and so this would just streamline the process of information sharing between Post and the law enforcement agency. And with that, we have Director Misselt here for any questions about it.
All right, and Director Misselt, did you have any testimony as well?
Thank you, Madam Chair and members. Just to say that this bill does not break new ground for us. We have had extensive discussions about the data that we have, or that the Post Board has had for years and years. We've handled private and confidential data for many years without any issues. Secondly, this brings us up to speed with what other licensing boards already have. So I would just close my remarks at that, stand ready for any questions. Thank you.
All right, are there any other members of the public wishing to testify on this bill? Not seeing any. We do have another amendment. Representative Scott, I believe this is your amendment, the A1. Would you like to move it and speak to the amendment?
Yes, thank you, Madam Chair. So the A4 just...
Yours, I believe, is the A1.
Oh, I am sorry.
As long as I know what's
mine in
going on,
first?
it's fine.
Oh, okay, I'm sorry, the A1, yes. This is just requiring any board member that has access to non-public data to be trained in by the Minnesota Government Data Practices Office. And when the bill was heard in public safety, the question was that are these people trained in how to handle this kind of information? And I don't know if it was the testifier sitting at our table, but someone testified that the staff is trained in how to handle the data, but the board members themselves were not. So this is just, we talked to the Data Practices Office and said that, yes, they do this sort of training. So that's what the amendment is.
Right, Representative Curran to the amendment.
Thank you, Chair, and thank you, Representative Scott, for the amendment. I agree with you in the intent of this amendment. I will be asking for a no vote on it tonight, just because it singles out the Post Board itself when we're looking at boards having training on this data. So I would be happy to pursue something that requires a broader scope of boards to have data training or data privacy training.
All right, any further discussion to the A1? Representative Johnson.
Chair Becker Finn, Representative Curran. This is a little
Curran.
different.
Representative Curran.
Curran. This is a little different than most boards. These are doing investigations into very sensitive data. Some of it, looking at it actually could be a possibility from investigations into a criminal offense, which could still be ongoing. So I think it's important that they understand the implications and what's going on with the data that's protected under Chapter 13.
All right, Representative Curran.
Thank you, Chair, and thank you, Representative Johnson. And I believe the amendment that, to the bill would rectify that specific issue about reviewing information that's in a current criminal investigation.
Representative Johnson.
I'm good.
All right. Any further discussion to the A1? All those in favor, please say aye.
Aye.
Opposed?
No.
No. Motion does not prevail. On to member discussion to the bill as amended with the A4. Any discussion to the bill? All right. Representative Curran, closing comments.
Thank you for the discussion. I look forward to future conversations about data privacy. It's something that's important to both of us, so I look forward to it.
All right, with that, Representative Curran renews her motion that House File 822 as amended be placed in on the general register. All those in favor, please say aye.
Aye.
Aye. Opposed?
No.
The motion prevails. Thank you, Representative Curran, and thank you for your patience. We had that on the agenda a couple weeks ago and didn't get to it. Maybe that was last week. Next up, I've got a Representative Berg bill. I believe I saw her walk in. House File 2442. I will move to recommend that House File 2442 be placed on the general register. Representative Berg, please tell us about your bill. And as we discussed, the portion of your bill that's before the Judiciary Committee is the Remedies section. Representative Berg, please go ahead.
Thank you, Madam Chair and members of the committee. I'm excited to present House File 2442, which protects employees' freedom of conscience by prohibiting employers from forcing employees to listen to the employer's opinion about religion or politics, including whether or not the employee should join a labor union. The scope of the bill does not apply to communications necessary for the employee to perform their job duties. That is the gist of the bill, the substance of which was heard and passed out of Labor Committee on a bipartisan vote. With that, it will briefly cover Subdivision 2, Remedies, which is the jurisdiction of this committee. Subdivision 2 allows employees to bring civil action in district court against an employer who violates this section within 90 days of the alleged violation. The court may award the employee injunctive relief, reinstatement, back pay, reestablishment of benefits, and any other relief deemed necessary to make the employee whole, including reasonable attorney fees. This is similar to other enforcement mechanisms in Chapter 181, which deals with employment matters. And with that, I have a couple of testifiers I will turn the time over to.
All right, first up, I have Kip Hedges, and then I have Kaylee Johnson on deck. Are either of those people here? All right, if I call your name, we need you to come down. All right. Welcome to the committee. Please introduce yourself and proceed with your testimony.
Well, thank you for having me here this evening. My name is Kaylee Johnson, and I'm a music therapist and founding committee member of Professionals United for Safety and Health, a division of SEIU Healthcare, Minnesota, and Iowa. We are a union created by and for social workers, therapists, music therapists, occupational therapists, art therapists, and therapeutic recreation specialists at the West Bank of the University of Minnesota Medical Center in Inpatient Behavioral Health. After our intent to unionize was made public in December of last year, we were invited to a series of programming meetings for all clinical staff, which were facilitated by management, leadership, and by members of the Human Resources Department. Though we were not explicitly told that this was required, our email invitation had required next to our names. We did not receive an agenda before this meeting. After a brief moment of gratitude from those running the meeting, the tone changed quickly. We quickly came to realize that this meeting was not at all about how to improve clinical programming in mental health. The meeting focused heavily on supposed facts about the union that we were building. In this meeting, they provided incorrect dues rates, incorrect benefit information, and told us that this third-party union would interfere with our ability to communicate with management, creating confusion and doubt in the union we were forming ourselves. They sought to discredit those of us who had spent years doing the work of creating the union that represents who we are. My colleagues and I felt the intimidation that was intended for this hour-long meeting that happened in 3 separate meetings. People were afraid of retribution for speaking out and asking questions in these meetings. We are all at-will employees, and the fear of reckoning for speaking out could have severe consequences for any of us. People were afraid to have the conversations with us about the union that we had had for months leading up to this point. We had to strategize to undo the damage that this meeting had done, putting out the small fires and doubts created by this hostile environment. Thankfully, our vote was successful, and Professionals United for Safety and Health now has a legal voice in the workplace. This was not without struggles and stressors stemming from this meeting and other tactics used to intimidate our work group. By banning these captive audience meetings, it will ensure that those of us seeking to form a legal voice will not be subjected by intimidation that many of us experienced in the last couple months.
All right, thank you for your testimony. Next up, I have Kip Hedges. If Kip is not available, next on the list, I have Brian Rains. Welcome to the committee. Please introduce yourself and proceed with your testimony.
Thank you. My name is Brian Rains. I'm a business representative with the North Central States Regional Council of Carpenters. Good evening, committee members. I'm testifying in support of the legislation to ban captive audience meetings by employers because our current legal infrastructure makes organizing labor unions in most workplaces too hard for regular folks. This legislation will make our state a stronghold for workers' rights, protection of our residents from dishonest anti-union harassment at their jobs, and make the benefits of union membership more accessible for Minnesotans. Employers hold an enormous material advantage over ordinary workers, and this fact becomes most obvious when workers try to organize labor unions. Relying on threats of discipline or termination, employers coerce workers into attending captive audience meetings where union busting is the central theme. An analysis by the Economic Policy Institute reveals that employers then use such meetings to lie about the benefits of labor union membership, excuse me, and engage in aggressive lawbreaking, like threatening to close workplaces, strip workers of benefits, and reduce wages in retaliation for workers exercising their rights to form unions under the National Labor Relations Act. To be precise, EPI's 2019 report shows that U.S. employers are charged with violating federal law in 41.5% of all union election campaigns. Like most Americans, I know that labor unions are good for workers. Further research by EPI demonstrates that far more U.S. workers want unions than have the benefit of representation today. When workers have union representation and bargain collectively, their wages, benefits, and working conditions improve. On average, union workers earn higher wages than their non-union counterparts and are likely to have employer-sponsored health insurance, paid vacation, sick leave, and retirement plans. Union workplaces are safer than non-union workplaces. Union workers are covered by due process protections so that, unlike non-union workers in the United States, union workers cannot be fired at will with no warning and for almost no reason. The residents of our great state deserve the good wages, generous benefits, and fair working conditions that come with union membership. This bill makes those outcomes more possible. I urge you all to support this legislation. Thank you.
Thank you for your testimony. Next on the list, I have Jason Adkins. Please introduce yourself for the record and proceed with your testimony.
Good evening, Madam Chair and members of the committee. I'm Jason Adkins, Executive Director of the Minnesota Catholic Conference, the public policy voice of the Catholic Church in Minnesota. We are not here to oppose the bill today. We welcome the intent of the bill, which is to combat union busting, and think that is a good policy objective. What we are concerned, though, is the scope of the legislation and the overbroad nature of what is defined as political and religious speech, and especially the remedies here, the potential of facing a civil lawsuit, we think makes the language in the bill require some further consideration. I think the obvious question from a standpoint of our concerns is how is the decision to join a union an inherently political issue? And that's perhaps the problem with the bill, is that political is defined so broadly in this legislation that anything can be understood as political, especially if it has a nexus with legislation, which many, many topics do. And that's really, I think, the significant part of our concern. So, for example, could a non-public school who requires teachers to sit in on presentations related to education legislation, is that within the scope of their duties? And there is that provision about something being within the scope of their duties, and that's important. But it's not teaching, it's legislation. Is that within the scope of the duties? Could a Catholic parish, for example, require its men to attend a presentation by the Knights of Columbus, a fraternal organization that also includes a pitch for membership. Would that be political speech? So in closing, we would just say maybe some further consideration needs to be given as to how this impacts the work of religious and advocacy organizations, and maybe some further consideration should be brought to that matter. Thanks very much.
All right, thank you for your testimony. Is there anyone else from the public wishing to testify on this bill? All right, not seeing any, we'll move on to member discussion. Representative Niska.
Thank you, Madam Chair, and Representative Berg. I would like to start with the question raised by Mr. Adkins' testimony about how this applies to employers that, for example, are community, fraternal, or labor organizations, or political parties, or religious organizations. There's no carve-out in the bill for those organizations. So how is this going to apply in those circumstances? Can they require their employees to come to any mandatory employee meeting, or is there? How do we deal with that, with the First Amendment interests of those kind of organizations?
Representative Berg.
Thank you, Madam Chair, and thank you, Representative Niska, for the question. This does not interfere with your First Amendment rights. This bill basically says your employer cannot require you to attend meetings where some of these things that do not apply to the scope of your job would be discussed. However, if you choose to, because you are interested in legislation, if you're interested in a certain topic that has come to your parish, you certainly can. What they're saying is, for example, many of you know one of my jobs outside of this is a flight attendant. If my employer calls me in, I'm going to assume it's about new things happening with our company, new safety requirements, new equipment on the plane. What I do not consent to is if I go in there and they want to tell me all sorts of things about their religion or their political views, nor would I want to share that with them in that environment. So again, if this has to do with the scope of your job, then that's the sort of meeting you can participate in, and you should be expected to participate in as an employee. If it doesn't have to do with your job and you want to attend the meeting, great, but you cannot be forced to.
Representative Niska.
Thank you, Madam Chair, and Representative Berg. I appreciate that. I'm still concerned by the way the language of this bill works, and in particular how the remedies work. And I'm trying to get a little bit at, I want to understand a little bit better what it means to be an aggrieved employee that can bring a civil action. So in particular, the prohibition includes any discipline, even if it's discipline about an employee making a good faith report of a violation. And so I was wondering if an employee has a good faith objection to a mandatory sexual harassment training that an employee, that an employer requires them to go to, where the trainer talks about the drawbacks and concerns about the severe or pervasive standard in Minnesota, and expresses the view that that should be changed, and the employee makes a good faith report that they think that mandatory training violated this new section 181.531. Could the employer reprimand them for that, or would they then become an aggrieved employee with a civil action?
Representative Berg.
Thank you, Madam Chair, and thank you, Representative Niska. And I recognize you're a lawyer, and I am not. That's a little convoluted for what I think the intent of this bill is. I do have someone here with me that can answer questions. In that case, that is something that is germane to what is happening in that meeting. So that is not my understanding of what would happen, but I'm going to let Melissa answer that so that you get an accurate answer.
Please introduce yourself and go ahead.
Thank you, Madam Chair. Is this on? Mm-hmm. Madam Chair and Representative, members of the committee, my name is Melissa Heising. I'm Legislative Director at the Minnesota AFL-CIO. I would point you to lines 2.15 through 2.17. Under scope, the section does not limit the rights of an employer or its agent, representative, or designee from communicating to its employees any information that is necessary for the employees to perform their lawfully required job duties. So in this case, if you're talking about a required sexual harassment training, that would be a lawfully required job duty.
Representative Niska.
Thank you, Madam Chair, and Representative Berg, and I appreciate that answer. The concern that I have that I think that is not being addressed is that there's also a provision that an employee is permitted to make a good faith report and that the employer is not allowed to make any discipline about that. So for example, if at a mandatory gender training, the company's objection to, for example, South Dakota's policy on gender affirming care is expressed, and an employee loudly objects to being subjected to that, I think under the bill, the employer then is potentially subject to civil liability. So I'm just really concerned about, I understand, and a lot of the discussion has been tied towards labor law, and I can understand if we could do a narrowly tailored bill towards labor law, but the way that this is written is very, very, very sweeping, and I think really, really needs to be rethought.
Representative Berg, any response?
Thank you, Madam Chair, and thank you, Representative Niska. We talked a little bit about this in the retiring room, and it's a great point, right? I'm certainly open to more discussion, and I think the scope of the bill as written is to be inclusive of several different entities and how they may operate. And I hear you about going to a meeting that is required and is part of your job, and that comes up. So that's certainly something to consider moving forward.
All right, any further discussion to the bill? Representative Johnson.
Chair Becker-Finn, Representative Berg. I understand the concept and what you're trying to do on this, but as Representative Niska said, I think it's a little too overbroad. We have a number of Christian schools, Christian and religious institutions at our colleges and our universities where there's time, because you have the religious in here, it affects them greatly, where they might have to have a mandatory meeting because of changes in the doctrine in their church that's sponsoring them. And now, because of that doctrine and the staff that's working with students and the staff at all, completely, they might have to change things, how they react to things because of the doctrine of that particular university or school or the doctrine of the church that's sponsoring them, where it's a religious obligation to be there, but now with this bill, they can't do that. But they need to be there to learn the new changes in the doctrine of that religious institution. So, like as Representative Niska said, this is just too broad, and it needs to be narrowed down just to the labor part of it. And if you are going to keep it this way, I'd like you to bring the schools into it, so students aren't forced to go to political events like they've done in the past. I've had parents just yelling and screaming at me.
Representative Johnson, the issue before us is whether the remedies in this bill are appropriate to what's in the bill. It's been fully vetted by the Labor Committee, so if we could focus on that, that would be great.
I understand, but like I say, it's just too broad, and it's could open up a huge can of worms.
Representative Scott.
Thank you, Madam Chair. Representative Berg, from my reading of this and also my understanding, although it's limited with employment law, is that if you were in a room and an employer was trying to proselytize you, that would already be something that you could sue on or report, because that would be considered religious harassment at work. So I'm trying to put these on a scale and see why the religious piece of this needs to be here when there's already a remedy in current law that would address the issue of the scenario that I just described.
Representative Berg?
Thank you, Madam Chair, and thank you, Representative Scott. Good question. I'm going to let Melissa answer that and then follow up if you have further questions.
Director Heising?
Madam Chair and Representative, could you restate the question?
Representative Scott?
Thank you, Madam Chair. Yes, so in a situation where under current law, if you are in a meeting with your employer and they are trying to quote unquote shove their religion down your throat or talk about religious issues and you feel threatened by that, you already have grounds under current law to file a harassment suit under religious harassment. And so why would we need this section in the bill that addresses the religion piece when there's already a remedy in law?
Director Heising?
Madam Chair, Representative, I'm not sure what law you're referring to, but if it's the First Amendment, if it's First Amendment rights, those are difficult to enforce in the workplace and there are no remedies or there are not damages for that. This bill provides a simple, clear, enforceable standard in state law that everyone can understand.
Representative Scott?
Thank you, Madam Chair. Well, you could sue under the Minnesota human rights law for religious discrimination or religious harassment under current law. So I don't see the value in having this. To me, it's just creating a complicated scenario for our religious institutions to say, well, can I talk about our own faith in our own institutions? So I see what you're trying to get at with the union side of this, but I don't know why. I mean, Representative Berg, is there a problem right now that is overwhelming in the workplace where you're hearing that this is happening, where people are being harassed on a religious basis?
Representative Berg?
Thank you, Madam Chair and Representative Scott. I think there's always issues that come up regarding politics, religion, organizing a labor union. Often it's not reported, so I could not pull out a chart that says this is the data. But I want to address something that you said, and actually Representative Johnson also mentioned. I went to a religious college. That was my choice. So every time I was in a class or every time I attended a forum, I knew it was going to be based on my religion. That was the choice that I made. If you work for the organization that the other testifiers, the Catholic organization, and you go to a meeting because you have chosen to work there, the assumption is that it is going to have something to do with the religion or the doctrine. These are all choices that people have made in these sort of individual niche places of work. What I'm saying is, if you are a music therapist, if you are a flight attendant, if you are anything that is not inherently religious or political, and you are called into a meeting that you assume is going to have germaneness to your job, and these other subjects are discussed, that's what's covered in this bill. And oftentimes, as employees, we are intimidated. We are thinking, oh my gosh, I can't speak up, I'll lose my job, how do I support my family, I'll lose my house, my car, all the things, right? And so that intimidation keeps us sometimes in place in meetings where this is a violation, where we are uncomfortable, where it is not germane to the scope of our jobs. If I choose to sit there and have a discussion with my manager about how wonderful it is to be able to go to church and have these great big feelings and enjoy these meetings, great. But I can't be forced to. And that's all this is coming down to, is it's a choice. And this gives you a backstop if you are stuck or continually approached about any of these subjects in any meetings that have nothing to do with your job. So I hope that provides some clarity, at least on the religion part.
Representative Scott?
Thank you, Madam Chair. And you mentioned continually approached. Is that in the bill? That you have to be
Representative Berg.
continually approached, or could it be just a one-time event?
Representative Berg.
It is my understanding it could be a one-time event. I apologize, I come from a labor background, and we are often continually subjected to union busting tactics. So that was my background coming to play. It's my understanding, even if it's just one time, this bill would provide a remedy for that.
No
Representative Kraft?
further questions.
All right. Seeing no further discussion, Representative Berg, closing comments.
Thank you so much, Madam Chair. And honestly, really great discussion. Your thoughtful questions always make the process a little bit better. I think we covered the contents of the bill. I just really hope for your support. I think this is a great thing for workers, and I think we can all agree on that. Thank you, Madam Chair.
All right, I will renew my motion to recommend that House File 2442 be placed on the general register. All those in favor, please say aye.
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 Opposed?
No.
The motion prevails. Thank you, Representative Berg.
First one to vote every time.
He's quick. Representative Kraft, I think I saw you in the room. All right, Representative Kraft, I will move to recommend that House File 1275 be re-referred to the Transportation, Finance, and Policy Committee. Welcome to the committee, Representative Kraft. I understand you also have an A3 amendment. Would you like me to move the A3 amendment?
Yes, please.
All right, I will move the A3 amendment. Can you please tell us what it does?
Yes, it's actually just finishing up some compromise language for smaller municipal and cooperative utilities that wasn't quite done in time for the hearing in the Transportation Committee.
Got it. All right, all those in favor of the A3 amendment, please say aye. Aye. Opposed? The motion prevails. The amendment is adopted. Representative Kraft, please tell us about your bill as amended.
Thank you, Madam Chair. Members of the committee, great to be here. I'm happy to be bringing House File 1275 on pipeline safety before you today. In order to prevent damage and ensure safety, Minnesota requires excavators to provide notice before digging and for utility operators to mark the location of underground utilities. Many people may know this program as 811, Call Before You Dig, or Gopher State 1 Call. This system is overseen by the Minnesota Office of Pipeline Safety, or MinOps, within DPS, and seeks to ensure projects that require digging do not damage underground facilities such as gas lines or utilities. The bill focuses on two things: updating civil penalties to match federal requirements and improving the data and visibility to performance on locate requests. I believe it is the civil penalties that is under the area of law of this committee. On civil penalties, MinOps has been informed that they need to increase, the penalties need to be increased to match federal guidelines, otherwise they could lose the ability to undertake enforcement actions. This is in sections 5 and 6 of the bill, and there have been no issues raised by any stakeholders in this area. The rest of the bill language around the locate and marking process has been created because MinOps needs better data from utilities, and the bill is making a previously voluntary process mandatory. This set off a lot of back and forth stakeholder engagement, somewhat unexpectedly, but it was all good. The current bill language represents what I feel is a good compromise and seems to make improvements in the process, but doesn't give any party everything that they want. This is a far more complex area than I expected, and there's definitely more to be done on this process. But I'm not convinced that some of the language now being requested, for example, in the A4, needs to be done legislatively. I actually agreed to carry a related bill, HF 2717, initiated by excavators, because it's my intention to get all parties together after session, get all issues on the table, and then ask them to work together to resolve them and come back to us before next session. By the way, Representatives O'Neill and Hudella have agreed to participate in this with me in a bipartisan fashion.
Welcome to being the excavation guy for the rest of your time in office.
Oh, my.
I understand you do have a testifier, Deputy Director John Wolfgram. Please introduce yourself and proceed with your testimony.
Good evening, Madam Chair and committee members. My name is John Wolfgram. I'm the Deputy Director of the Office of Pipeline Safety. I'd like to thank Representative Kraft as well as the committee for the time that everyone's put in looking at this bill and the engagement with stakeholders. This bill, as Representative Kraft put very well, this involves not only our call before you dig laws in our state, or those excavation safety laws, it also involves our state pipeline safety regulations. These are the regulations that apply to companies that transport hazardous liquids and natural gas to homes, buildings, institutions, and facilities. I'll keep my comments brief and primarily focus on the second component of the bill, which aims to increase our pipeline safety civil penalties as noted in Minnesota Statute 299F and 299J. This bill works to adopt the federal pipeline safety provisions in Title 49 CFR Part 190. The Office of Pipeline Safety often on an annual basis participates in annual grant reviews that are conducted by the Pipeline and Hazardous Safety Material Safety Administration, or PHMSA. PHMSA comes out and audits our programs. They audit our policies, our practices, and our procedures as a part of our grant guidelines and grant funding we receive. The last number of years, the Office of Pipeline Safety has received notification from PHMSA that our current pipeline safety civil penalties under statute are not commensurate with the federal provisions in Part 190. With that, PHMSA has noted that we would potentially lose funding for our pipeline safety programs related to underground natural gas storage. And most recently, PHMSA has stated that the Office of Pipeline Safety will no longer be able to issue enforcement in follow-up to those violations, rather that enforcement would have to be issued by PHMSA. With that, I'd be happy to answer any questions that the committee might have.
All right, we got a couple other members of the public signed up to testify, so we'll move on to that. I've got Tony Mendoza, and then I have Sarah Pasick on deck. Please introduce yourself and go ahead with your testimony.
Good evening, Madam Chair. My name is Tony Mendoza. I'm counsel to the Minnesota Cable Communications Association, and thank you for the opportunity to testify about House File 1275 and in support of the A4 amendment. Minnesota law currently requires underground facilities to be marked within 48 hours after submission of a locate request. However, many of these requests are not made in good faith. Some are submitted with no intent to excavate for projects that are already completed and for areas that are so large it would be impossible to excavate the area within the 14 days in which the locate ticket is valid. These abuses divert investment away from progress towards Minnesota's 2026 goal of universal broadband service and instead waste these investment dollars on unnecessary locates and paying or challenging fines for technical violations of the law based on late locates. OPS is not going to be able to find its way out of this problem, and fines only make the problem worse by tying up resources responding to violation notices. The A4 amendment addresses the problem of bad faith locate requests, ensuring that the funds intended for building infrastructure like broadband won't be wasted on unnecessary locates and challenging or simply paying OPS fines. The A4 amendment will greatly improve this bill and make the Gopher State One Call system work better and safer for everyone. Thank you.
All right, thank you for your testimony. Next up, I have Sarah Pasick. Please introduce yourself for the record and proceed with your testimony.
Thank you. Good evening, Madam Chair and members. I'm Sarah Pasick, and I'm here on behalf of the Associated General Contractors of Minnesota in place of Laura Ziegler tonight. I'm not going to say much. We look forward to working with Representative Kraft this summer and others. And as he said, it's a complicated area, and
he's the excavation guy.
He is now, and we're excited to work with him on that. On this bill as well as the other one. We do support the reporting requirements in this bill, or the reporting system that is the kind of underlying part of the bill, as well as the update to federal standards. I do have to just comment on the letter and the comments by Mr. Mendoza that we take exception with the frivolous requests for locates. AGC's number one goal is protecting our workers, protecting the public, and preventing damage to underground utilities. And so we think that gathering this reporting and meeting over the summer should hopefully bring a good result back to the legislature next year. So thank you, Representative Kraft.
All right. Are there any other members of the public wishing to testify on this bill? All right, not seeing any, we will move to the aforementioned A4 amendment. Representative Niska, I believe that's your amendment.
Thank you, Madam Chair, and yes, I'm not used to having so much discussion about my amendment before I get to present it, but yes, I move the adoption of the A4 amendment, which is really designed to create two protections to make sure that the remedies here are properly balanced and calibrated. The first is a procedural protection that a party is not going to be not going to have their participation in this reporting used against themselves in an enforcement action. It's kind of analogous to me of the the Fifth Amendment right, although that's not, obviously the Fifth Amendment isn't strictly applicable in this circumstance, that we're just not going to put someone in that position where they have to essentially provide evidence against themselves for an enforcement provision. And the second protection is to create a good faith standard when penalties are being applied. It's kind of the flip side of a willfulness requirement that we sometimes put into penalties. In this case, it's that there has to be, and I appreciate that most contractors, I think, are making good faith requests, but if they're not making good faith requests, that's not something that could be the result. It could result in penalties. So that's the purpose of the A4 amendment, Madam Chair.
Representative Kraft to the A4.
Madam Chair, thank you, and Representative Niska. Did I hear in that you wanted to become excavation guy?
Absolutely.
Look, I'm gonna ask for a no vote on this. These are issues that have been discussed in quite a bit of detail in the prior committee. I appreciate some of the points. I will say on the first one, the won't be used to initiate action, but if they have data that's been collected and there's things that have come up, you might as well be able to use the data because it could help as well. And on your other point, I'm just not convinced that legislative solution is the best solution. So I'm committed to work this, as I've said, and come back. So with that, I would ask for a no vote.
All right, Representative Johnson, is this to the A4?
This is to the
Okay, go ahead.
Chair Becker, Finn, members. I'm going to ask that you do support this. It wasn't that long ago that one of our locate people, personnel, were not getting to do the locates. Everything would be done, and by the time they finally got to the position to do their locates, it had been sometimes 60 days since the other locates were done, where they finally had to come back to redo the locate so our townships could actually replace culverts. There's nothing in this proposal in the bill that requires them to do the locates in a fashion, in a reasonable time period. And part of it is because of there's so much work going on that if they have maybe they are trying to locate 100 miles of road where they can't get that done in that 14-day period. But this would make it so our other people that need these locates done get them done on time and not have to wait 30, 60, 90 days to get it done and have to have all the other locate people come back.
All right. Any further discussion to the A4? All those in favor, please say aye.
Aye.
Opposed? No. The motion does not prevail.
Excavation guy.
Excavation is so exciting.
I think we won.
Who says we don't have fun in this committee? All right, on to member discussion of the underlying bill. I have Representative Carroll.
Well, I was just going to say, and this is perhaps a little off topic, but since you
Not off topic, Representative Carroll.
okay, yes, ma'am. Yes, Chair. So since you bestowed the moniker on him of the excavation guy, I think another appropriate one would be Larry the Cable Guy.
It's true. Oh, no. I didn't do that. I did not do that. Representative Kraft, I do, when I mentor new members, I do say, pick a couple things and get really good at those things. I don't, sometimes you fall into them. And those are your things. Representative.
Please end this.
Representative Kraft, closing comments.
Please re-refer the bill out of the committee. Thank you very much.
I renew my motion to recommend that House File 1275 as amended be re-referred to the Transportation, Finance, and Policy Committee. All those in favor, please say aye. Aye. Opposed? The motion prevails. Thank you, Representative Kraft.
Retire now.
Right, we're done. Representative Tabke. We'll see if we have as much fun with Representative Tabke. We won't. I will move to recommend that House File 1350 be placed on the general register. Welcome to the committee. Please tell us about your bill.
Thank you, Madam Chair and members. So this is the DVS policy bill, and so it has a variety of technical issues that are in here and some other policy issues, and we have Mr. Pangjong from DVS to go through the bill if you would like, or we can just answer questions. It's whatever you would prefer to do on this bill.
We would prefer to stick to the only reason this bill is here, which is Section 11, Subdivision 5C. Director, if you'd like to introduce yourself and just speak to that portion, that would be great. We don't need a full walkthrough.
Thank you, Madam Chair. Pong Zhang, Director of the Driver and Vehicle Services Division. Madam Chair and committee members, Section 11 is really to add a caretaker provision so that credential holders can provide information about either adult dependents or young children that they are exclusively in care for, and that data will then be leveraged if in an emergency situation, and this data will be considered private.
Okay, thank you. I don't have any other members of the public signed up. Any other members of the public wishing to testify on this bill? All right, moving on to member discussion. Any discussion to the bill? All right, Representative Tabke, closing comments.
Please vote for the bill. Thank you.
All right. Renew my motion to recommend that House File 1350 be placed on the general register. All those in favor, please say aye.
Aye.
Aye. Opposed? The motion prevails. Thank you.
Madam Chair.
Representative Freiberg, you're up. Representative Freiberg, I will move House File 2392 be placed on the general register. Representative Freiberg, welcome to the committee. Please tell us about your bill.
Thank you, Madam Chair, members of the committee. If you could just give me 1 second to pull up my notes.
Nope, we don't have 1 second.
I think that will save everybody time because I want to focus on only the issues that are relevant to this committee. So we're talking about 2392?
Correct.
Okay, thank you. So this is a bipartisan campaign finance board agency bill that clarifies a bunch of laws related to campaign spending. I believe there are only 2 provisions that are relevant to the Judiciary Committee, so I will focus on those. Section 3 adds a fix related to ballot question committees. There's a penalty provided if an independent expenditure committee or fund makes a contribution to a candidate, but current language does not extend that penalty to a ballot question committee that contributes to a candidate. Section 9 clarifies the penalty for failing to close caption campaign advertisements or provide radio scripts on websites. Candidates that sign public subsidy agreements must close caption television advertisements and provide the script of radio advertisements on the candidate's website, but there is no penalty provided. So this bill would establish a $1,000 maximum civil penalty. I just want to mention that the board rarely uses the maximum penalty for a first-time offense. There were violations at the past election, however, where the board could only determine that a violation occurred, but there was no penalty possible. Jeff Sigurdsson from the Campaign Finance Board is here. I know if there are any technical questions, but that's what I have to say.
All right. Thank you for sticking to those provisions. Any other members of the public wishing to testify on this bill? All right, not seeing any. We'll move on to member discussion. All right, not seeing any. Representative Freiberg, closing comments.
This is an agency bill. I think would make some needed changes, and I encourage members to support it.
All right, I will renew my motion to recommend that House File 2392 be placed on the general register. All those in favor, please say aye.
Aye.
Aye. Opposed? The motion prevails. Another Representative Freiberg bill. Representative Freiberg, we've got House File 1140. I will move to recommend that House File 1140 be placed on the general register. Representative Freiberg, please tell us about your bill.
Thank you. So this is This bill includes various technical and small policy items related to election administration, and I believe there are 3 sections in this bill that are in the purview of the Judiciary Committee, so I will summarize those. Section 7 provides that the list of individuals who selected a particular party ballot in the presidential nomination primary is only available to that party. Secretary Simon, I know, met with both party chairs who agreed to this change. This change will require minor programming changes to the report provided at the conclusion of the presidential nomination primary. Section 23 permits local elections officials to engage in absentee voting activities in state veterans' homes and in certain shelters for battered women in the same manner as permitted in hospitals and other healthcare facilities. Section 67 provides clarification on what data is public from cast vote records. And Nicole Freeman, I think from the Secretary of State's office, is here if there are technical questions.
All right. Any other members of the public wishing to testify on this bill? All right, moving on to member discussion. Members, any questions on the bill? Representative Scott.
Madam Chair, if you'll allow me, there's a section in the bill, and I'm probably not going to be able to find it, but it talks about candidates being able to assist voters in filling out their ballots. Are you familiar?
Representative Scott, that would not be before the jurisdiction of this
I'm dying
committee.
to know the answer.
But I bet you could find Representative Freiberg after committee and ask him. Any discussion to the provisions in the bill that are relevant to the jurisdiction of this committee? All right. Not seeing any closing comments, Representative Freiberg.
Thank you, Madam Chair. Representative Scott, look forward to talking to you about that provision. It's a great provision.
We'll see, yeah. Right.
All right. Seeing no further discussion, I will renew my motion to recommend that House File 1140 be placed on the general register. All those in favor, please say aye.
Aye.
Opposed?
No.
The motion prevails. Thank you, Representative Freiberg. Representative Carroll. Representative Carroll, I don't really care which one of your bills we do first. Which one would you like to do first?
Well, let's do the first one mentioned, the cancer report.
1329, all right. Representative Carroll, would you like to move House File 1329 be referred to the general register?
Yes, I would.
All right. Please tell us about your bill.
You know, I almost said, yes, I would, Your Honor.
No, thanks.
I know. You know, this is a straightforward bill from the agency, and I'll just, in the interest of time, I'll turn it over to my testifier and let him walk through it.
All right, please introduce yourself and proceed with your testimony.
Hello, Madam Chair. My name is Jay Desai, and I'm with the Minnesota Department of Health. And I just wanted to point out that this bill has been heard several times previously in this committee. And as a result of those discussions, we have made some modifications to the bill, specifically line 1.17 and 1.18, where we added some clarification that there are research protections for patients will be consistent with Minnesota State Statute 13.04 Subdivision 2, as well as the Code of Federal Regulations Title 45 and Part 6, which referred to common law and human subjects protections. Additionally, researchers' abilities to directly reach out to cancer survivors in the Minnesota reporting system is highly vetted, follows all the federal and Minnesota human subjects and data privacy laws, and has numerous layers of protection for the data. And so I'll leave it at that for now.
All right, thank you. We do have one member of the public signed up. I have Twyla Brace. All right, please introduce yourself for the committee and proceed with your testimony.
Thank you, Madam Chair and members of the committee. My name is Twyla Braze. I am president and co-founder of Citizens Council for Health Freedom. I'm also a registered nurse. Our organization exists to protect patient and doctor freedom, and protecting privacy is key to protecting freedom. So I'm here today to share our concerns about House File 1329. So CCHF believes patients have a right to privacy, including a right under the Minnesota Constitution, Article 1, Section 10, to be protected from warrantless searches and seizures of their data by the government, whether it's state government or, in the case of the U.S. Constitution, federal government. The cancer surveillance system has long violated the individual's right to privacy because it does not require consent for the ongoing collection of the patient's data or contact by researchers. House File 1329 would expand this privacy violation in two ways. First, in line 1.16, consent from the physician is eliminated and replaced by a simple notification requirement. It's also not clear what qualifies as a physician notification. Is it an email that could be missed, a written letter, and could that contact occur before the letter to the physician even arrives? Removing physician consent removes all protection for the patient, allowing state officials to contact without warning the patients and their families, regardless of their current situation or their wishes. Second, it begins sharing patient data outside of Minnesota. This is precedent setting. To our knowledge, cancer surveillance data has not been shared outside the state before, and this bill would not only start to do it, but would do it without the patient's consent. Lines 1.19 through 2.2.
Ms. Braze, I'll have to ask you to wrap up.
Oh, I'm sorry, Madam Chair, I had not been given a number of minutes.
It's 90 seconds, and all testifiers who signed up ahead of time were notified of that.
Oh, okay. Thank you, Madam Chair. So I will say two more things. I think what I'll say then is that there is a thought that de-identification in the lines 2.3 through 2.7, which is allowing to share with the government without the patient's consent and without certain information.
All right, thank you for your testimony.
And the de-identification does not.
Yep, when I asked you to wrap up, it didn't mean start up where you left off. So thank you for your testimony.
Thank you, Madam Chair.
Yeah, thank you. Any other members of the public wishing to testify? All right, not seeing any. We'll move on to member discussion. Representative Scott.
Surprise, surprise. Thank you, Madam Chair. To the testifier from the Minnesota Department of Health, if I might, and thank you, Representative Carroll, for reaching out about this bill and let me know it was coming. I've always had a problem with this cancer surveillance piece. It should never have been allowed to form without the patient's consent. You're sharing their name and their very personal medical records. And so I'm wondering if you could give me some idea, Mr. Desai, why that was. If you were around when they started this surveillance system, why was it that the patient's consent was never gathered?
Manager Desai, if you're able to answer that. I don't know how long you've been doing this job, but.
Madam Chair, committee members. Yeah, the Minnesota Cancer Registry started in 1988, and I was not around at that time. But right now, we do not share, I mean, part of what is in here in lines 2.3 through 2.7 are explicitly stating, since we've begun, we've been submitting data to the CDC and to the NIH so that the data can be included in national registries. Lines 2.3 and 2.7 explicitly state that we do not share name, social security number, telephone number, street address, or other identifying information when we provide that data to the CDC and NIH for national registries. So we do not share that private data.
Representative Scott.
Thank you, Madam Chair. Well, I'm talking about existing language on the first page. Notwithstanding a lot of the contrary, including sections 13.05, subdivision 9, data collected on individuals by the cancer surveillance system, including the names and personal identifiers of persons required in section 144.68 to report. It's private data, but you're collecting it and putting it in Minnesota's database without the patient's consent. And that's what I'm asking about is when Minnesota formed their own cancer surveillance system, why wasn't patient consent obtained from the get-go?
And this will be the final follow-up I'll allow on this, since, the current law isn't really what's before us, it's the changes that are being made, but
Yes, and so that's one of my concerns. That's not addressing what's currently being proposed here. That's addressing something that occurred back in 1988. And there are a variety of reasons why. Minnesota is, every state has a state cancer reporting system. And consent for participation, for data being shared into that reporting system does not exist in any other state either, right? Because it compromises the data, we get incomplete data, unbiased data, or biased data if we do that. And so that then limits our ability to really provide accurate results around cancer, to be able to accurately identify areas where there might be concerns for us to follow up on. And then it really renders the database scientifically not valuable for reporting on, for monitoring cancer.
Representative Scott.
Thank you, Madam Chair. Whose data is it? Whose data is it going into your system?
Manager Desai.
I'm not sure how to answer that question.
That's fair. Representative Scott.
Thank you. It's a simple question. Is it your data, is it government's data, or is it the individual's data?
Manager Desai.
Yeah, again, I'm not sure how best to answer that question. We have conditions that are reportable to the department for the social, for community good and for social good that we use, and the cancer reporting system is one of those data systems.
All right. Representative Scott.
Thank you, Madam Chair. Are there other surveillance reporting systems or other databases at the Department of Health that do not require patient consent if their information, identifiable information, is going into the system?
Manager Desai.
We have reportable conditions, a variety of particularly infectious diseases. That's been standard practice for Department of Health, throughout the country and elsewhere for a long time.
All right. Representative Scott, any further follow-up?
Yeah. Thank you, Madam Chair. So, Mr. Desai, if I had an amendment saying that the patients must give their consent to go into this database, would the Department of Health oppose that?
I can't speak for the whole Department of Health.
Representative Carroll.
Thank you, Chair and Representative Scott. That's a hypothetical. What we're dealing with is the bill before us.
All right. Thank you, Madam Chair. Well, I guess, is this going to the floor? Was that the motion?
Yes, it's going to general register.
Thank you, Madam Chair. So I'll be bringing an amendment to the floor that requires patient consent to go into this reporting system. I think if you're dealing, especially if you're dealing with cancer, the last thing you need is some strange government person calling you up that you didn't even know had your data. And the cancer patient goes, "Why are you calling me, and how did you get my data? How did you get my personal health record?" Because patients don't know right now. And I think that's a problem. So thank you, Madam Chair.
All right. Any further discussion? Representative Carroll, closing comments.
Thank you, and I appreciate the conversation we've had, Representative Scott. I learned from you, and I appreciate that. The point of it is, as you pointed out, that the data is private. And so I think there's protections along that, and I just ask for this committee's support.
All right. Representative Carroll renews the motion to recommend that House File 1329 be placed on the general register. All those in favor, please say aye. Aye. Opposed?
No.
The motion prevails. Thank you, Manager Desai. Representative Carroll, will keep you there for House File 2539. Would you like to move House File 2539 before the committee?
Yes, I would.
And then I understand you have an A1 amendment. If you could, would you like to move the A1 and then tell us about it?
I would.
All right, please go ahead.
So the amendment does two things. It waives the court filing fees for the name change process, since this would have been a free service if we weren't changing the law, and it eliminates a reference to Chapter 259.13 that wasn't included in the original bill.
All right. All those in favor of the A1, please say aye.
Aye.
Opposed? The motion prevails. All right, we've got the bill in the shape that you would like. Representative Carroll, please tell us about your bill as amended.
Thank you, Chair. And again, in the interest of time, I have some testifiers who can expedite the process.
All right. Are you Barbara? Or are you
Julie?
All right, I had two names, I guessed wrong. Julie Hanson, if you could introduce yourself and then go ahead with your testimony.
Absolutely. Thank you, Madam Chair, members of the committee. My name is Julie Hanson. I'm the Property and Customer Service Manager for Scott County. I'm here today to testify on behalf of the Minnesota Association of County Officers, of which I am the co-legislative chair. What I'd like to let you know today that we support House File 2539. We thank the representative for bringing this forward. The name change process through marriage is confusing and complicated if you happen to be a felon. It causes confusion both for the applicants as well as the staff trying to process these, and we love the fact that this would streamline the process. It can be complicated. We give marriage licenses over the counter to everyone else. Folks that are felons come in and we have to stop the process and go through a whole long 30-day process for them. So again, we support House File 2539, and I'm happy to stand for questions. Thank you.
Thank you for your testimony, and then I have Barbara Olson. Please introduce yourself and go ahead with your testimony.
Greetings, Madam Chair and members of the committee. My name is Barbara Olson, and I manage the Hennepin County Vital Records Unit, which has oversight to marriage records in Hennepin County. I have over 30 years of experience working with vital records. I'd like to walk through some situations that we've encountered at Hennepin County specific to this bill. So applicants with a felony conviction who want to change their name via the marriage process are required to ask the prosecuting authority for permission to change their name and to wait 30 days. However, in these instances, mail can be delayed on both ends of the process or even lost so a response is never received. Also, in the absence of a response from the prosecuting authority, the name change is considered approved. There have also been instances where the prosecuting authority responses were received after the 30-day waiting period, and fortunately, we were able to respond quickly and ensure that a marriage license was not issued with a name change. And lastly, we have applicants who come into the service center to obtain their marriage license not knowing that there's a 30-day waiting period and if they want to change their name. The applicant has to choose at that time between moving forward with their original wedding plans or to wait 30 days to change names. Applicants at that point typically decide to not change their names due to the 30-day waiting period. I would appreciate your support for this bill. Thank you for the time tonight.
All right, thank you for your testimony. Are there any other members of the public wishing to testify on this bill? Not seeing any, we'll move on to member discussion. Representative Finke.
Thank you, Chair Becker-Finn and Representative Carroll. I just want to thank you for bringing this bill. I think the number of ways that we make people with felonies' lives ridiculously complicated needs to change. So I appreciate these. I appreciate this a lot.
Thank you. All right, closing comments, Representative Carroll.
I just ask for your support, and let me just say as an aside that Ms. Olson, I seem to recall she helped me when I needed to get birth certificates for my children. She was a wonderful servant then, and I appreciate it. So I appreciate the committee's support. Thank you.
All right. With that, we're going to lay over this bill. That's the plan. So we're going to lay over House File 2539 as amended.
Thank you.
All right, last up, Representative Bahner. I will move House File 2257 before the committee. Representative Bahner, welcome. I understand you have the A2 amendment. Would you like to move that first?
I do. Thank you, Madam Chair. I would like to move the A2 amendment.
All right, I will move the A2 amendment. Please tell us what that amendment does.
Sure. It does about 4 basic things. The first, it exempts broadband services from the scope of this legislation. Second, it adds a new definition section. These definitions are consistent with widely accepted and respected tech industry standard definitions based on the Washington model. It also moves the business size thresholds into the scope section of the bill for added clarity. And the fourth thing that it does is it changes the term personal information to personal data.
All right, any discussion to the A2? All those in favor, please say aye. Aye. Opposed? The motion prevails. The amendment is adopted. Representative Bahner, to your bill as amended.
Thank you, Madam Chair and members. I am proud here tonight to present House File 2257, the Minnesota Age Appropriate Design Code, or AADC. With 20 years in the IT industry, the last 10 leading teams in software product development, I'm so excited to share this bill with you today. With an active IT caucus, the Technical Advisory Council, which is a flourishing public-private partnership, actively working to meet the tech challenges today in a way that puts people first, that makes Minnesota uniquely positioned as a leader on this issue. Today, most online products are designed with profit in mind and not people, and especially not children. This bill aims to change that by creating a model for all states to follow, leveling the playing field, setting clear rules of the road for businesses without creating a patchwork of laws that serve no one. Our grand online experiment called the Internet has failed our youth. It has failed to protect their data and privacy, and candidly, it has failed to protect our kids, period. Here are a few statistics. Roughly half of teenagers 13 to 17 report they're worried about spending too much time on their devices. 52% of U.S. teens reported having tried to take steps to cut back on their mobile phone, social media, and video game use. 75% of the top social media platforms use AI to recommend children's profiles to strangers, including adults, often including explicit photos or videos. 90% of girls and 50% of boys say they are frequently or sometimes sent explicit photos or videos while online. 58% of girls and young women report they have been harassed or abused online. But there is a silver lining. The AADC represents a vetted regulatory framework that is proven to work. It's passed in the UK in 2020. It is rooted in the principle of data privacy and product safety. If we can do it for cribs and cars, we can certainly do it for children under the age of 18. We've already seen a wave of change. For example, Instagram now prevents adults from messaging children. They don't know. They've turned off location tracking by default and introduced prompts to encourage children to take breaks from scrolling. TikTok made accounts under 16 private by default and stopped sending notifications to users 16 and younger after 9 p.m. It is at its core, House File 2257 is simple. It requires businesses to gather only the data required and to provide the services requested, and prohibits the sale or further use of that data. Secondly, it requires online platforms to take an honest look at their products and their practices and assess whether that product presents a risk to children. This bill is proactive, not reactive. Risks need to be mitigated or eliminated before the product is offered to the public. We use this approach every day, again, from cars to cribs, and it can work for the internet too. It's time to put the interests of children ahead of corporate profits. This bill is reasonable and balanced. Companies in the UK have already found a path to compliance. U.S. children, Minnesota children deserve no less. Moreover, House File 2257 doesn't require content moderation, doesn't infringe on parents' right to raise their children. More importantly, it doesn't limit the information, opportunities, or resources available to youth online. But rather, it ensures youth can access all of the opportunities the internet has to offer without the risk of harm from predatory data collection and exploitation. And with that, I do have with me today Nicole Roca, who is here with 5 rights to be able to speak a little bit more to the bill.
All right, welcome to the committee. Please introduce yourself and proceed with your testimony.
Good evening, Chair and committee members. Thank you for the opportunity to speak here today. My name is Nicole Rocha, and I am the head of U.S. Affairs for 5 Rights, an international NGO dedicated to building the digital world young people deserve. When it comes to the internet, we know that the status quo isn't working for our youth. In addition to addiction, we are seeing shockingly high rates of teen depression, harassment, and sexual abuse. This is not an accident. The digital world is 100% engineered and largely privately owned, and it is a system designed to optimize engagement for profit. HF 2257 solution is rooted in data privacy principles and based on international work that we know produces results and has long been part of our business culture, product safety. If the risk of harm to children is part of a platform's design, the solution comes from redesign. The bill contains 3 elements that represent a true paradigm shift in how we look at tech. It defines children under the age of 18, unlike federal law that defines the age of adulthood on internet at the age of 13. It applies to online products that are likely to be accessed by children rather than those directed at them. We often say we don't need to make Sesame Street safer. We need to make the places where children actually and youth spend time online safer. Finally, it requires these protections by design and default, thereby removing the onus from the parents and placing some of it on tech itself. Representative Bahner has done an excellent job describing the bill, so I would like to leave plenty of time to answer questions from this committee. 5 Rights would like to thank the sponsors, this committee, and the state of Minnesota for considering these important design protections for youth. Thank you.
All right, are there any other members of the public wishing to testify on this bill? All right, not seeing any, we'll move on to member discussion. All right, closing, Representative Scott.
I do have a question, Madam Chair. Thank you. And I'm still looking for the language, but I think it talks in here somewhere about age appropriateness. Does that ring in a bell to the author of the testifier? And I'm just wondering who would determine age appropriateness.
Representative Bahner. It would help if we knew where we were looking.
Well, this, Madam Chair, thank you.
Representative Scott.
Actually, the citation on 1.16, 1.17, it's in the title, Minnesota Age Appropriate Design Code Act.
Sure, if I may.
Ms. Rocha.
So we know from research that online platforms, for the most part, can pinpoint their audience's age within a degree of 6 months. There are recognized windows of development for children. You know, it's like 0 to 3. So there's like nonverbal, verbal. You know, we continue going up, and then we have older teens that are getting closer to adulthood and exercising some autonomy online. And if these platforms know the ages of the audiences that are accessing their services, then they also can perhaps design a little bit more appropriately for those ages. I don't think my 8-year-old is looking at The Economist, right? But you might have some older teens who are doing that. And so there is a wide variety of platforms and ages that are being accessed. A lot of the online games are for general audiences, and these platforms know exactly how old the actual users of those games are.
Representative Scott.
Thank you, Madam Chair.
All right. Representative Bahner, closing comments.
Now, I think this bill is a critical first step in really kind of, again, changing the way we look at how we put things out there into the world for children. You know, we have for a long time, we have waited until the harm already occurs before we actually do something about it. This bill is really saying, let's address those concerns up front. Let's do it in a way that sets clear rules of the road for tech companies to follow, that has a level playing field for those companies, that actually makes it easier to do the design, by the way, as someone who works with those design teams, and do it in a smart and targeted way. We have been doing this in literally every industry out there, and this is one of the final frontiers to say, yes, we should in fact have some rules of the road when it comes to children and how we keep their data and their privacy sacred. And so with that, members, I would ask for a green vote.
And I'm actually going to update my motion. I had moved the bill before us. We put the amendment on. I'm actually going to move that we recommend to refer this bill back to the Commerce Committee, since that's the original jurisdiction. I would rather not have it sitting in my hopper, and our Chair Stephenson can have it back. All those in favor of the motion to move the bill back to Commerce, please say aye.
Aye.
Opposed? All right, House File 2257 as amended is on its way back to Commerce. Thank you, members, for your focus. With that, we are adjourned.